Annabel Nelson and Derek Latimer, sixth formers still at school, might be thought a little young to be going courting. Yet that is all they claim they were doing when they slipped through a hole in a wire fence. The fence, though, was around a building site, guarded by dogs and men employed by the security firm of Transecure Limited. The dog in question, Fury, chased them back outside the fence, where he bit and savaged Annabel, causing very serious injuries. In a fracas, as Frank Page, the dog's handler, ran up, the boy was struck by a truncheon and sustained a fractured skull. Today, Page stands accused of possessing and assault with an offensive weapon, and, together with Transecure Managing Director Gerald Somerville, of occasioning grievous bodily harm by the agency of a dog. Another Transecure guard, William Cook, though he took no active part in this, is also accused of possessing an offensive weapon. All three have pleaded not guilty. For the Crown, Charles Lotterby has finished his opening speech and is examining the first prosecution witness.
I swear by Almighty God that the evidence I give shall be the whole truth, nothing but the truth, so help me God. John James Minter, Police Constable, stationed at Fulchester Police Station.
Were you on patrol at Elm Bottom on the night of December the 27th?
No, sir. I went in response to a call on my radio and arrived there 3 or 4 minutes after. 3 minutes before the police patrol car and ambulance.
And what did you find, Constable?
2 Transecure guards and...
Can you see them in court?
Yes, sir. There.
And?
And 2 figures, both lying on the ground, covered by coats. A boy and a girl. The boy was unconscious and the girl hardly conscious.
They've been left lying there on the cold ground?
They were injured, and I believe the proper first aid procedure is not to move injured people until medical help arrives.
I see.
They were covered by coats, sir.
What else did you see?
There was also an Alsatian dog.
And this dog, what was he doing?
Just standing there, sir, on a leash.
On a leash, under restraint?
No, not restrained, really, sir, just on a leash.
Not growling or straining at the leash?
No, sir.
And did you examine the young people lying on the ground?
Yes, the girl was bleeding from deep wounds in her neck, left arm, and hands. There was some blood on the dog's muzzle. I formed the opinion that the dog had bitten her.
Though it now appear docile enough.
Yes, sir.
And did you examine the dog closely?
Yes, there was a slight abrasion on the dog's side, which might have been caused by a kick, and some blood on the dog's chest came from a cut below its jaw.
Injuries of a kind which could have been caused by the girl's attempts to defend herself, or not?
I should say they could have been, sir.
And the boy's injuries?
There was some blood in his hair. He was unconscious. I thought he'd been hit on the head. I'm not a medical man, sir, but I think they were right not to have moved him.
Was there anything there which might have been used to cause this blow to the head?
He was clutching a piece of wood, but unless he had hit himself, there was only the guard's truncheons.
Both guards were carrying truncheons?
Yes, sir.
Now, where were these 4 people and the dog with reference to the building site and the fence?
Outside the wire fence, on the grass verge between the fence and the road.
Outside, not on private property?
No, sir.
Now, Constable, you're a police officer trained to observe, aren't you?
Yes, sir.
From where you were standing by this group of people, could you see a hole in the wire fence?
It wasn't obvious, perhaps, but it was there to be seen.
And could you see any notice warning that dogs were patrolling on the other side of the fence?
No, sir, not there, but further
By
along...
the hole in the wire, there was no visible notice warning of guard dogs?
No, sir.
Nor any notice warning of anything else, for that matter?
Not by the hole in the fence, sir, no.
Now, one final matter. Whereabouts on the boy's head had he been struck?
Well, from the blood on the right side of the head.
To the front or the rear of his head?
On the side, sir, just above and behind the ear.
But on the back of his head rather than the front?
Yes, sir.
Now, would such a blow be more likely to be delivered from the front or from behind?
My lord.
Mr. Lloyd?
My lord, the witness was not there to see the blow, nor is he in any sense an expert, so that my learned friend is surely asking for witness's opinion.
My lord, the witness saw the result of the blow. Now, I maintain that this police officer, by the nature of his work and training, is more expert than most on such a question.
No, Mr. Lotterby, it is opinion, and you have neither called the constable as an expert witness, nor have you established that he has any special qualifications in that respect.
Very well, my lord.
You may, of course, try to establish his qualifications.
It's not important, my lord. Now, Constable, you say that a police car and an ambulance arrived some minutes later. Now, what happened then?
The young couple were taken to hospital and detained for treatment. The 2 guards accompanied myself and the patrol car officers to the station, where they assisted in preliminary inquiries and were released. Later, when police inquiries were completed, they were charged.
Thank you, Constable.
Mr. Lloyd?
You've given your evidence well and clearly, Constable. I don't think we need to quarrel with any of it. A couple of points, however, perhaps you could clarify for the jury.
Yes, sir.
You said that there were no warning notices on the fence at the actual spot where all this took place.
Yes, sir.
However, were there warning notices elsewhere along this fence?
Yes, sir.
How many?
I don't know, sir. I didn't go all the way round the fence, just along the road to where they were all standing.
A journey along the fence of how long?
100 yards or so?
And how many notices did you see along that stretch?
2 or 3, sir.
Plain for all to see?
Yes, sir.
Now, the road along which you or anyone must travel runs parallel to this fence, does it?
Yes, it does.
When you received the call on your radio, you went straight to the building site, did you?
Yes, sir.
You knew where you were going. You were familiar with the place.
Yes, sir.
Would you be so good as to tell the jury why you were so familiar with the place?
Because there have been any number of complaints already about it. A lot of trouble. Complaints by the new owners of damage and pilfering. And some of these I had investigated.
The new owners?
The land was sold for building, sir. The firm that bought it, I mean.
Why do you know so much about it?
The local paper was full of it, sir, and there was a lot of talk about it.
Oh, why?
Elm Bottom is a local beauty spot, sir, and some people object to the land being built on.
And some of the people had taken the law into their own hands. They'd gone to this building site to damage fences, to pull down notices, and generally to cause mischief, hadn't they?
Yes, sir. Several people were taken to court and prosecuted.
And local courting couples might well be amongst those who objected to the building work and to the fence, since Elm Bottom offered woods and privacy.
It was a place for courting, sir, but I don't know of any courting couples being prosecuted.
But then again, they had to be caught to be prosecuted, didn't they?
Yes, sir.
In fact, that there had been so much damage and mischief was the very reason that the firm of Transecure was employed to guard the site.
Yes, sir.
Hearsay, my lord?
Would you be so good as to tell this court how you know this?
Because I advised the site supervisor myself to get someone in.
By someone, do you mean a private security firm?
Yes, sir, I do.
You took it upon yourself to give this advice?
Yes, sir.
Although, strictly speaking, the job of guarding such places and preventing damage and mischief might well be held to be a police responsibility.
Yes, sir.
Well then, were you and your fellows not doing your job properly then?
Yes, sir, but the police force is undermanned, short of men, always busy, and it's impossible to be everywhere at once. A job like that really needs some special firm to come in.
My lord, this witness was called for the prosecution. Now it seems he is to be a spokesman for the entire police force.
My lord.
I don't believe my friend has established the witness's qualifications for that either, my lord.
Mr. Lloyd?
My lord, in the interests of streamlining justice...
Streamlining justice, Mr. Lloyd.
Of brevity, my lord, I wanted only to establish the valid need in this country for private security firms to aid and to support the police.
Then I think you have managed to make your point, Mr. Lloyd. Perhaps you should move on to other questions.
Yes, my lord. But while I had a police witness here, my lord, I had hoped to use him to establish other and similar facts.
And what are they?
Well, I wish to ask the witness if he was aware that private security firms today employ even more men than the police force itself.
I see no reason why you should not, if that is a fact.
And whether he knows, as a policeman, that many of these men regularly and normally carry police-type truncheons as part of their everyday equipment.
Yes, sir.
But that none of these men, these very many men, has ever before been charged with possessing an offensive weapon simply because they need to carry truncheons in order to defend themselves.
Now I see where you are leading us, Mr. Lloyd. This is not presently a proper or relevant line of questioning.
Perhaps so, my lord, but will you now entertain a submission that William Cook, charged only with possession of an offensive weapon, to wit, a truncheon, be forthwith dismissed from the case?
I most certainly will not. Courtroom tactics or no, Mr. Lloyd, you are well aware that this is not the time for any such submission. You may ask me to consider it at the end of the prosecution case.
But meanwhile, my lord, many damaging and unnecessary
I have
imputations.
ruled, Mr. Lloyd. Have you finished your cross-examination?
Very well, my lord.
Mr. Lotterby.
No re-examination, my lord.
Thank you, Constable. You may stand down.
Thank you.
You may return to your duties.
Thank you, sir.
I call Annabel Nelson. realise that this is your first time in a court of law? It can be a bit scary. You take your time. We'll bear with you.
Yes.
Now, I asked you, did you and your friend Derek Latimer go to Elm Bottom along the road where the notices were placed?
We didn't see any notices.
And why was that?
Well, we cut across the fields and came out opposite.
You cut across the fields and crossed the road only at the point opposite the hole in the wire fence.
Yes, more or less.
More or less?
Well, it was dark and we didn't come out exactly opposite.
Now, Miss Nelson, I have to ask you this. Why were you making for Elm Bottom?
Well, we knew there was a hole in the fence there.
But you knew it was by then a private building site.
Yes.
And why were you looking for a hole in the fence to go inside it?
We were looking for somewhere private.
To be alone?
Derek and I, yes.
You went straight to a hole you knew to be in the fence so that you could go inside into the woods to be alone with your boyfriend.
Yes.
How did you know there was a hole in the fence?
Well, there'd been a hole there before.
How long before?
The night before and the night before that.
And on the previous evening, had there been any guards or guard dogs or any warning notices?
No, I mean, there'd been an old night watchman, but not dogs and things. The firm only started that day.
Well, how do you know that Transecure only started working that day?
I found out afterwards.
But on this night you saw no notices and you had no way of knowing that there were any guard dogs or professional hired guards patrolling the place?
No.
Now, when you went inside the fence, was it with any intention of doing damage or simply to be alone with your boyfriend?
Just to be alone.
You didn't see any a warning notice and pull it down?
No.
Now, will you tell us what happened when you went inside the fence?
Well, all of it.
From the time you were seen?
Well, we were just sitting and...
And kissing?
Yes.
Of course you were, most people have. What happened then?
Suddenly there were whistles blowing and someone shouted. We stood up and then this great huge dog came snarling and growling.
Yes.
We ran. We ran back to the hole with the dog chasing us, Derek and I, him pulling me along. We scrambled through the hole and then there was a man in uniform coming towards us and shouting.
What was he shouting?
I don't know. Just words. We scraped through the hole and the dog came after us. It was coming for me. Derek had a piece of wood and he tried to stop it, but it went round him and came for me.
You were still running?
I suppose so, but looking back, and then the dog jumped at me. I tried to kick it, but it knocked me over and bit my arm. I fought it, but it bit me and bit me and...
I'm sorry I have to make you remember it all, Miss Nills. It must have been a terrifying experience.
Yes.
Now, this dog, it followed you through the fence, and it was there that it first came at you.
It was outside the fence that it first jumped at me and bit me.
Now, I don't expect your memory is very clear about what happened when you were lying there on the ground with this great dog savaging you. But can you try to tell us anything else you can remember?
Derek hit it or kicked it. I felt him hit it. And then the guard came, first one, then another. He was shouting at me to keep still and the dog to stop, but I couldn't keep still with a dog on top of me. Eventually, they pulled the dog off me, and I looked round for Derek. I couldn't see him, and I saw him lying on the ground. And then the guard put coats over me.
You didn't see how Derek came to be hurt?
I had the dog on top of me. I couldn't. Honestly, I didn't. He was just lying on the ground. And the guard who was putting coats on me was crying, I think, and saying how terrible it was and things like, oh, God, no. Then a policeman came, and I think I remember being in an ambulance because I remember hearing the siren noise, and then cold sheets and nothing till the next day.
How long were you in hospital that first time?
About 3 weeks, and then they let me go home.
And later?
Oh, I had a lot of, plastic surgery operations.
Your face and neck have healed very well, haven't they?
Yes.
Do you have any permanent effects from this attack?
My arm, there was a bit of flesh missing, and they can't make flesh. I have a hole and bumps and scars and things on my arm, and I can't play the piano now.
Thank you very much, Miss Nelson.
You're a very brave, very pretty young lady, and I'm cast in the role of villain. I will have to ask you all sorts of questions that you may not like. I'm sorry.
Yes.
Tell us a bit about yourself. You're 16 and studying for your A-levels at school.
Yes, that's right.
In how many subjects?
6.
Just 16, and already you have your O-levels and you're taking 6 A-levels. You're a very clever young lady, aren't you?
Thank you.
And self-possessed. Well, what are your hobbies?
I used to play the piano.
Yes, and we know that you're courting. What other sorts of things do you do with yourself?
All sorts of things.
Do you have a debating society at school, a drama group?
Yes, both.
And you enjoy debating?
Yes, I'm the first lady chairwoman they've had.
And you like acting?
Well, yes, quite.
Oh, more than quite. You're close to being the school star, aren't you?
No.
No? You've taken the lead in the last 3 productions, haven't you?
That doesn't make me the school star.
And level-headed, too. So you're clever, pretty, good with words, level-headed, cool and self-possessed. A young lady of many resources. Many more depths and talents than one would guess by looking at you. Aren't you?
Aren't I what?
A shrewd, complex girl.
I don't know.
I wonder if you're shrewd enough to make us believe what you want us to believe. Was there a branch of the Save Elm Bottom Society at your school?
I believe there was, yes.
You believe? You were the secretary of that too, weren't you?
There was a branch, yes.
And you were its secretary. Now, why did you say believe as if you'd hardly heard of it?
You asked me 2 questions, and I wanted you to know that I was answering the last one.
What a clever answer. Well, what sort of things did members of the Save Elm Bottom Society get up to?
Meetings, protests, you know. Some people wrote to the local press and some went to see the builders.
And some members went to the building site and pulled down fences, destroyed fences and property and made mischief, didn't they?
So I'm told.
And you went to Elm Bottom yourself?
Well, not to
You
pull
went to
down...
Elm Bottom knowing it was private?
Yes.
Knowing how to get through a fence which had been put there for the very reason of keeping out people like you?
No.
No? Well, you have said in evidence that you did.
Well, you're bullying me.
No, indeed, I'm not. I'm only trying to get at the truth. How many times did you go to Elm Bottom after it became private?
I don't know.
Well, an estimate. 10, 20, 30, more times?
It was over months.
How many times?
Dozens of times.
You went onto this land, knowing it was private, knowing you were trespassing, knowing you had no business there, dozens of times.
Well, it was ages before they started building work.
Now, you climbed under fences, you took an active part in a protest movement against it, you trespassed, you held meetings, you wrote to the press, and you knew all about it. And yet, you have claimed not to have known that the firm of Transecure were employed to guard the site.
I didn't know.
Do your parents subscribe to the Fulchester Express, the local newspaper?
Yes.
And the Elm Bottom controversy was pretty fully reported in that, wasn't it?
Yes.
Did you not follow developments in this paper yourself?
Sometimes.
You even wrote 2 letters to this paper yourself, and yet you claim not to have known that the firm of Transecure were to be brought in, then had been brought in, and finally would commence operations on the 27th of December last.
I knew there was talk of it. I didn't know it was settled, and I didn't know it was started.
You didn't read it anywhere?
No.
Nobody mentioned it to you?
No.
None of your friends?
No.
None of the members of your society?
No.
No. Well, isn't that strange? Knowing your interest, suddenly, from an active interest, you go to a complete blank in your knowledge, and nobody tells you anything so important. Dozens of times. You say you went to Elm Bottom dozens of times. Well, what on earth did you find to do there on private land dozens of times? Yes?
I went walking.
Walking through a building site, through small holes in a wire fence.
Yes, I've walked and played at Elm Bottom since I was a child.
And you objected to anybody trying to stop you doing that now?
Yes.
Objected enough to make a hole or 2 in the fence yourself, I expect.
My lord, I've sat through all kinds of insinuations, flagrant badgering of this witness. Now, Miss Nelson's not on trial here. She's done nothing, been charged with nothing. She's the victim of this terrible business.
No, Mr. Lotterby. Mr. Lloyd must be allowed to develop his cross-examination.
Thank you, my lord.
Sir, can I answer it?
Yes, God.
Well, if I don't, it looks as if I can't, and there's something to hide now. Please, may I answer?
Yes, indeed you may answer. Please do.
All right. I pushed wire aside. I even broke a post once by accident, but I never made a hole in that fence. I never needed to. There were plenty of holes already made by boys and I don't know who else.
Miss Nelson, my admiration for you grows by leaps and bounds, and you're only 16. So you went dozens of times to Elm Bottom and sometimes just for a walk. Or what else did you go there for?
I went with friends.
Friends?
Yes.
Amongst whom was sometimes Derek Latimer?
Yes.
Your boyfriend?
Yes.
And sometimes with other friends?
Yes.
Other boyfriends?
Yes.
Dozens of times? Well, nobody would blame you for that nowadays, but now I'm puzzled. You see, I had an impression of you, perhaps we all did, as an ordinary, shy, 16-year-old maiden. Nice, unsophisticated. But you've proved me wrong. You're not at all like that, are you? How would you see yourself?
I don't know what you would call ordinary.
It's an extraordinary answer. You see, you might have said many things, but again, you have said the thing that makes you seem simple and modest. Dozens of times, you say that you went to this place for courting couples, dozens of times, not once, not several times, but dozens of times. Is this right?
I suppose so.
Yes? Well, is this a picture of yourself you're happy to leave us with?
Yes.
Why did you go there on the last occasion, on the 27th of December?
To be somewhere quiet with Derek.
How far from Elm Bottom do you live?
Couple of miles.
A 2-mile walk on a winter night. Now, was there really nowhere nearer you could go just to kiss him?
No.
I ask you again, why, on the 27th of December, did you really go with your friend to Elm Bottom?
To be alone with Derek.
To make love?
My lord, this
this witness is certainly giving the impression that this was the reason for her visit to the woods. For her own sake and for other reasons, surely it must be made quite clear.
It's impertinent, my lord. It has no relevance to this case.
I'm bound to agree with Mr. Lloyd that the question, if embarrassing, may well have a great deal of relevance. I think we should hear the witness's answer.
Thank you, my lord. Miss Nelson, did you go all the way to Elm Bottom on the 27th of December last with your friend Derek Latimer to make love?
Yes.
The case of the Queen against Page, Somerville and Cook will be resumed tomorrow in the Crown Court. Yesterday, in the opening day of the Crown versus employees of Transecure, a security firm, we heard how two young people, Annabel Nelson and Derek Latimer, were severely injured by a guard dog and a man employed by the company. They had been trespassing, certainly, but claimed the assaults took place outside a wire fence protecting a local beauty spot, a lover's wood called Elm Bottom. During cross-examination by Defence Counsel John Lloyd, and despite an objection by Charles Lotterby for the Crown, which Mr. Justice Craig overruled, Annabel, just 16, admitted that she and her boyfriend had gone into the woods to make love. However, Lloyd has not yet finished.
Before we adjourned yesterday, Miss Nelson, you said that you went with your friend Derek Latimer to Elm Bottom in order to make love. Is that so?
My father says that's a rotten, dirty question and I don't have to answer it.
Miss Nelson, I respect the strength of your father's feelings. However, you are in court and I have directed that you will answer. Now, in case you do not fully understand, I will explain that in this court, my authority is such that you must answer. If counsel really feels it necessary to ask the question again.
I do. Thank you, my lord. Miss Nelson, will you answer it? On the 27th of December last, you went all the way to Elm Bottom, a walk of over 2 miles through mud and fields in darkness, because it was the nearest place you could find to make love.
Yes.
I don't think that the jury could hear that.
Yes, yes, yes.
And I dare say the events of that night will have fixed it firmly in your mind.
Before
the dog bit you, yes. Now, can you recall the weather of that night?
The weather?
Yes, was it warm, dry, wet, snowing, hailing, what?
Wasn't snowing.
No?
I don't know.
Well, I have here a local meteorological report of the weather on that evening. I wonder if it'll refresh your memory.
It was an ordinary sort of day.
It was night. And yes, the weather seems to have been the only ordinary thing on that night. It was intermittent showers, drizzle, temperatures just a little below normal for the time of the year. Not freezing, but cold and wet.
So?
Can you remember what your parents were doing that evening?
My parents? Well, they were out, I know, playing bridge.
They were out. Tell me, as a local girl, do you know such places as Bradley Woods, Castle Chase or the Copse?
Yes.
And they're all places where courting couples go, aren't they?
Yes.
And they're all within what, 1/4 of a mile of your home?
Not that near.
Well then, Miss Nelson, can you now explain to the jury why it was you chose to walk 2 miles through dark, muddy fields and to make love in a cold, wet wood where you might be disturbed by at least a night watchman, when you could have gone to at least 3 much nearer places, or better still, stayed in the warmth and comfort of your own home? You didn't make love at all, did you?
No.
No. And isn't the truth also that you really went to Elm Bottom knowing full well that Transecure were there and hoping to make as much trouble as you could for them?
No.
You pulled down the fences yourself, didn't you?
No.
You made the holes in the fences and pulled down the warning notices yourself?
No.
You knew that Transecure were there, guard dogs and all, didn't you?
No.
And you hurt that dog, you kicked it, provoked it, inside the fence first, enough to make it chase you, didn't you?
No, no, no!
No re-examination.
No, we did none of those things.
Well, Mr. Latimer, will you tell the jury what you did do?
Well, we got into Elm Bottom through a hole in the wire. The hole was there, we didn't make it. And we didn't know that there was guards or dogs there either. Well, first we knew was when someone spotted us and whistles blew. Well, then the dog came at us and we ran.
Why did the dog come at you?
Well, they're guard dogs, they're trained to.
Did you in any way provoke the dog?
Oh, yes, sir.
Yes. How?
Well, as I said, by running. Well, they're trained to attack a running figure. If we'd have known to stand still, we'd have been all right. But you don't think.
Yes. But did you provoke the dog in any other way? Did you kick or hit, hurt or touch the dog in any way while you were on the other side of the fence?
No.
Was there any reason other than that you were running away for the dog to follow you outside the wire?
No.
Why did you hesitate?
Well, I'm not sure. I thought at the time that one of the guards shouted, "Get them, boy." Well, it made me scared.
Get them, boy?
So,
Now, why have you become less sure of those words?
well, it could only have been the dog handler, him, Mr. Page. Well, he came to visit me in hospital, and I don't think he's the sort of man that would shout that.
Well, that's generous of you. But Mr. Page was shouting orders at the dog.
Well, I thought so, yes.
And you heard the words, "Get them, boy."
Yes, sir.
Now, will you tell the jury what happened from the time you began to run?
Well, we ran, and the dog was a fair way off, but Annabelle stumbled, and I thought she was going to fall. Well, then I took her hand as we ran, and we got to the hole and pushed through, and I scratched myself. Well, then we stopped, because I thought the man, Mr. Page, would call off the dog, but he didn't, and the dog came through the fence.
And then, didn't Mr. Page order the dog to stop?
Well, I didn't hear anything, no.
What happened then?
Well, I just stood there for a second, I'm afraid. It was awful. Well, then I ran and kicked the dog in the side. I was going to hit it. I had to stick up to hit it when the man, that's the dog handler, arrived. And he said, stop still, and things like that. Well, I thought the dog would obey him. So I turned and said, for God's sake, stop it, I think. Only he must have thought I was going to hit him or something, 'cause he came at me with a truncheon. Well, he hit me on the head, and I woke up in hospital.
With a fractured skull. Other than that, you made no move towards Mr. Page. Nothing he could have interpreted as an attack.
Well, only that I was still holding the stick, but nothing else, no.
Now, Mr. Latimer, why were you in Elm Bottom Woods in the first place?
Well, I went with Annabelle. We'd been walking, and it was near. Annabelle said she knew the way in, so I said, well, let's go.
Why?
What? Why did I say let's go in there?
Yes.
Well, it was private, and we thought there'd be nobody there except the old night watchman.
Now, I have to ask you this. Did you go there to make love with Miss Nelson? To make love with Miss Nelson?
No.
And why did you go there?
Well, to be with her, yes. Well, you know, I suppose, well, to neck.
In her evidence, Miss Nelson first said that you went there to make love.
She said that.
And later she said that that was not true.
Well, it's not true.
Well, have you any idea why she might have said it originally?
No. I mean, unless she was tricked into it.
My lord.
She was not tricked, Mr. Latimer.
Well, I don't know. Unless...
Unless?
Well, unless she couldn't bring herself to admit the other thing.
Ah, now this is the first we've heard of another thing. What other thing?
Well, I haven't made a secret of it. It's just silly, really. Well, see, we also went there to tease the old night watchman. He used to get angry and we thought it was funny. Well, not to him, I suppose. But a couple of times we went there and made sort of noises like ghosts and... Shouldn't I be saying all this?
You must tell the truth, Mr. Latimer.
Well, the first time we went there, we really scared him. And he chased us and we hid and he couldn't find us. We just thought it was funny.
A childish joke.
I'm afraid so. Thinking about it now, I suppose it wasn't really funny. Well, I mean, he had quite a lot to put up with, what with all kids always being in there, and people moving survey pegs and busting fences and so on. We just thought it was funny to see his face.
A childish joke that sometimes went too far. Now, did it ever go as far as pulling down notices, busting fences, or doing any damage to property?
Oh, no, sir.
No. You're quite an expert on guard dogs, aren't you? You know to keep still, that they only attack people who run.
I know now, yes.
You were inside the fence on private land when you picked up this lump of wood
Yes.
and threatened the dog with it.
No. Annabelle didn't fall, so we kept on running.
But a trained dog would be more likely to attack a man with a stick, wouldn't it?
It didn't, though. It went for Annabelle.
When you reached the fence, Annabelle went through first.
No, I did.
You did? Why?
Well, we'd closed the hole, you know, camouflaged it a bit behind us. I had to get it open.
While Annabelle stood rear guard for you, so to speak.
I suppose so.
So then, we have a long run, a stumble, a near fall. Then there's delay while you fumble in the dark to get the hole open again. Quite a lot of time must have passed.
I don't know. It seemed very quick.
Probably, but quite a lot of time for a running dog to catch up with you. Didn't the dog catch up with you then, and didn't you or Miss Nelson kick it then, while you were inside the fence?
No.
No? But the dog had reached the fence before you were through it?
No, it was near, but it wasn't there. I mean, we wouldn't have stopped to look, would we?
Where was the guard, the dog handler, at this point?
Not sure. Not so near, but near enough.
Now, you said that he came to see you in hospital.
Yes.
Why should he do that?
Well, he felt bad about what had happened. He came to apologise.
That was a nice thing for him to do, wasn't it?
Yes.
It was dark, of course, by the fence. There were no lights.
Yes.
So then it's likely that such a man simply could not see that his dog had gone through the fence, rather than he was so vicious and cruel as to let it attack you.
I don't know.
It's more likely, though, isn't it?
I don't know, because moments later he came through himself.
By which time you had turned and threatened the dog with your stick, and Miss Nelson had turned and aimed to kick at the dog.
Yes,
And she'd kicked at it before it brought her down.
No, I said it was going for her before she turned. She tried to turn and kick it.
Well, then, can you give any possible reason or explanation as to why this trained dog should ignore you, a man armed with a lump of wood, outcircle you, and go for an unarmed girl who offered no threat?
I think the dog had gone berserk. Well, it's not a question of a reason. It just wanted to attack someone. It was going for someone. I had a stick, so it went for Annabelle.
At which time you kicked it?
Yes.
Again?
No, only once.
When you'd recovered from your first paralysis of shock and fear.
Yes.
By which time the dog's handler had come up to you and was shouting advice to you and orders to his wounded dog.
The dog wasn't wounded. I'd only kicked it. He was there before I even hit it with a stick.
So you turned towards him with your stick still raised and held up. Would you show the jury how you held this lump of wood? Like that?
Yes.
No, keep it there for a moment. With your permission, my lord. Now, would you imagine that I'm the dog's handler and turn away from me? Now, turn back suddenly, as if I'd come up to you. Well, we can see now why Mr. Page thought you were going to hit him.
Well, perhaps, but he could see I wasn't going to.
Perhaps we're not all gifted with your powers of imagination.
I think he hit
You
me
think
because...
a great deal, Mr. Latimer. Like your friend. Is Miss Nelson still your regular girlfriend?
Well, no.
There was another hesitation. Why not?
I don't know. It's just how things happen.
You find out things about people.
Yes.
You change your mind about them. Are you a truthful person?
I'm on oath.
I'd not forgotten. Well then, Mr. Latimer, one final question. You've mentioned the moving of survey pegs. Now, this presumably would have the effect of spoiling work that surveyors would have done.
Yes.
A mischief that we'd not heard about in this court until you now come to mention it.
No?
No. So, on the nights that you went trespassing, causing mischief and frightening old men, did you also move a few survey pegs yourself?
No, I did not.
Then who did?
Mr. Latimer, there was a sentence you had no chance to finish. Now, what were you going to say? Why do you think the guard struck you?
Oh, not because he thought I was going for him. I hadn't even turned all the way round. And you can tell if someone's going to hit you anyway. I think he was so furious because I kicked his dog.
You hadn't even turned all the way round.
I started to turn, that's all. And I was saying, for God's sake, stop it.
So if you hadn't turned all the way round, the blow from the truncheon should have hit you somewhere on the back of your head.
Yes.
Now, where on your head did the blow land?
Oh, towards the back, yes.
And you think the reason the guard struck you was just because he was angry that you were kicking his dog, even though the dog was savaging Miss Nelson at the time?
He just run up. He hadn't seen what it had done to her, perhaps. He just acted like, you know, hit me without thinking. It's not black and white. I wish it was that simple, but I don't know.
I'm not sure the jury understood what you meant by that last remark.
Well, I've thought about it since, a lot, naturally. About why he hit me. He didn't think I was going to hit him. I don't believe that. Well, not unless they train people in his job to hit first and ask questions after. Well, all right, we've been trespassing and he chased us. But you don't just run up to somebody you're chasing and hit him over the head, do you? Well, not unless you're a brutal man. And I said I don't think Mr. Page is that.
Or unless truncheons have become so commonplace in your job that you can use them unthinkingly.
I don't know. Well, I said I don't know.
Now, one other little matter. You say that Miss Nelson is not your girlfriend now, and we've perhaps been led to wonder if this may be because of things you've learned about each other since these events. But were you ever boy and girlfriend in any serious sense?
I liked her. I still like her, but we're never really serious, no.
Now, Colonel, you are Chief Constable of the Fulchester area.
I was Chief Constable. I've just retired.
Oh, I see. Now, would you be good enough briefly to tell the court something of your career?
I was commissioned in the Royal Marines in 1931, served throughout the Second World War in the Mediterranean and the North Atlantic, rising to the rank of Lieutenant Colonel by 45. In 1950 was Colonel in command of the Royal Marines 5th Commando Force, retired service in 1957 September, and was appointed Chief Constable in February of the following year.
And weren't you awarded both the Distinguished Service Order and the Military Cross whilst on active service?
I was, yes.
Now, did your long and distinguished career give you experience of hand-to-hand and unarmed combat?
It did. Unarmed combat, now called close combat, by the way, is, of course, a commando essential. It is also a particular interest of my own. And close combat courses, training courses for men in my command, were something in which I took an active interest.
In the services, would close combat training include work in the use of truncheons, clubs, weapons of that sort?
Yes, where such weapons were to be used, the men would, of course, be very thoroughly trained in their use.
Now, do policemen receive training in the use of their truncheons?
Yes, indeed. by the hour. They are also trained, incidentally, always to strike, where it's necessary to strike at all, at an adversary's joints, his knees, elbows, so on, and never, never to strike at the head.
Never at the head. Now, do you know if Transecure employees receive training in the use of their truncheons?
I made it my visit to find that out, and they do not. The Transecure simply hands them the truncheons and leaves them to get on with it.
And what is your opinion of a truncheon as a weapon in the hands of an unskilled, untrained man?
It can be quite deadly.
Now, on the 28th of December last, Colonel Hore Davis, did you pay a visit to the Elm Chine District Hospital?
I did, yes.
Now, would you tell the jury the reason for your visit?
I wanted to see the children, Nelson and Latimer. I wanted to see for myself the extent of their injuries. I satisfied myself that they were indeed severe, and that the blow to the head had been delivered from behind.
That was an unusually conscientious action for a busy man to take, wasn't it, Colonel?
Well, it was, yes. I wanted to see for myself before charges were framed. I wanted to be sure that the charges were the right charges. Then later, when I handed on the papers to the Director of Public Prosecutions, I could be quite sure of my grounds.
Thank you very much, Chief Constable.
Am I right in believing, Colonel Hore Davis, that it was upon your recommendation that the guard Cook should be charged with possessing an offensive weapon?
It was by recommendation, yes.
Although the offensive weapon was no more than his regulation truncheon.
I do not know by what regulation he would be wearing a truncheon.
Well, whatever led you to make such a recommendation, as a policeman, you must surely be aware that thousands of these guards wear them all over the country nowadays.
I am keenly aware of that, yes.
And that never has even one of them been so much as threatened with a prosecution.
I am also keenly aware that their right to carry arms has never been established in law.
Arms? Oh, come on now. Arms is surely too strong a word.
Well, possibly it is.
Then the decision to prosecute was taken arbitrarily by you.
No, sir. It was my recommendation, not my decision.
But the Director of Public Prosecutions will rarely ignore the recommendation of a Chief Constable.
He has that right.
You decided, in other words, to make a test case out of this one unfortunate man.
This court will decide whether an offence has been committed. It seemed to me that there was a case to answer.
When you came to be appointed Chief Constable, what police qualifications did you have?
My service career?
You had no practical police experience.
I did not make my own appointment. Evidently, it was considered that my qualifications were sufficient.
Now, you said in evidence that when you visited the hospital, you satisfied yourself that the truncheon blow had been struck from behind.
Yes,
Well, how did you do that?
by determining that the wound was on the back of the head.
But a man ducking to avoid a blow might receive it on the back of his head, however he was standing.
It was also on the right-hand side of the head.
Well, what does that prove?
Well, a right-handed man striking another from behind would probably strike the other on the right-hand side of the head.
And you satisfied yourself, of course, sir, that Mr. Page is right-handed.
I did. I sent a constable to check.
Yeah. Well, how do you know that the blow was not delivered thus, across the body?
Well, of that I cannot be certain, but it's a very awkward way to handle a truncheon.
Now, your decision to recommend charges be brought against this unfortunate guard must have been one of the last decisions of your career before you retired.
One of many last decisions, yes.
To go out in a blaze of glory. If you were retired, you could not be held responsible for your actions.
Why not? A man is responsible for all of his actions at any time in his life.
Colonel, what are your personal feelings about security firms?
I have seen them proliferating and growing increasingly powerful. I do not prejudge this issue, but I feel that they are in danger of becoming paramilitary. I felt it was time somebody took a look at them.
That sounds rather like the sour grapes of a professional for the useful amateur.
I do not believe so.
Colonel, now you're a man of many parts, aren't you?
Which parts?
A soldier turned policeman, a doctor to look at a wound and guess how a blow was struck, a detective, and now a would-be lawyer to decide when the law should bring test cases.
This court is at perfect liberty to dismiss the charges.
No re-examination, my lord.
Thank you, Colonel. You may stand down.
That is the case for the prosecution.
My lord, this is the point at which you agree to hear my submission that William Cook be forthwith dismissed from the case.
I recall remarking, Mr. Lloyd, that courtroom tactics aside, the opening of the prosecution case was certainly not the time for such a submission.
Indeed, my lord. The police are not prosecuted because they carry truncheons, nor soldiers' guns even. Many hundreds of employees of private security firms have regularly carried truncheons unremarked for many years simply because they share with the police similar jobs, similar risks and dangers.
Yes.
Well, I would not argue, of course, that an individual should escape responsibility for anything he may do with his truncheon, but surely it is to bring the law into disrepute to prosecute an otherwise completely innocent man simply for carrying a necessary tool of his trade.
I anticipate you, Mr. Lloyd. I have considered this matter, and it seems to me that here we have two questions. Policemen do ordinarily carry truncheons without fear of prosecution, but the police are licensed so to do. To the best of my knowledge, however, private security firms enjoy no special status in law. They are bound by exactly the same restraints as the rest of us.
Yes, my lord.
Now, the second question is one of context and intent. An old man would not reasonably be prosecuted for possession of his walking stick or a Boy Scout for his knife. But a truncheon has but one purpose. That is to strike a blow. No one would deny the defendants their right to carry truncheons upon private property. But this was not the case with Cook, who had left the property he was employed to guard and was carrying his truncheon upon a public highway. Now, as to whether a truncheon is a dangerous weapon, well, we have heard the expert testimony of Colonel Hoare Davis. There is therefore evidence from which the jury may decide that a truncheon is indeed an offensive weapon. Accordingly, there is a case to answer. I direct that William Arthur Cook be tried as charged with the other accused.
Thank you, my lord. I call William Arthur Cook.
The case of the Queen against Page, Somerville and Cook will be resumed tomorrow in the Crown Court. In the last 2 days of the trial of employees of Transecure Limited, a private security firm, counsel for the Crown has presented the prosecution case that teenagers Annabel Nelson and Derek Latimer, trespassing on a building site, were chased off by a guard dog, which then savaged the girl. Dog handler Frank Page at the same time struck the boy with his truncheon and fractured his skull. Defence counsel John Lloyd has suggested that there was provocation. Today we shall hear Page's version of the facts, and it's been said that the dog Fury will appear in court. Meanwhile, Lloyd has applied to the judge, Mr. Justice Craig, to have another guard, who is merely charged with carrying his truncheon, dismissed from the case. The judge has ruled that he must be tried along with the other accused.
Just over 10 years with Transecure, sir.
Before that, Mr. Cook?
Well, I was a van driver at a milk round and then national service. I was with the Royal Military Police, 2 years with the military police.
Yes.
And I carried the truncheon then, sir, all the time.
A moment, Mr. Cook.
And I also carried the truncheon since I joined the firm. Nobody ever told me that
The truncheon you carried on the night in question. Now, was that, so to speak, sheathed, or were you wielding it?
Well, it was put away. There was no reason to have it out.
Why did you go outside the fence?
Well, to help. There was trouble. I went along to help.
To help whom?
Well, by the time I got there, sir, they were just lying on the ground, the boy and the girl. Nobody needed help but them.
So you went outside the fence as urgently as you could to help the boy and the girl?
Yes, sir. Naturally, I didn't stop to think to leave me truncheon behind.
No. The truncheon which was as much a part of your everyday equipment as your hat?
Cap, sir. Yeah. Yes, sir.
My lord, following your ruling, the defence is somewhat off balance. In view of the importance of the issues now raised, I am asked to request an adjournment so that we may confer with clients to consider the need to summon other witnesses and evidence.
Mr. Lotterby?
My lord, in view of the ever-mounting costs of legal proceedings, the Crown is always reluctant to adjourn when it is not strictly necessary. Other than that, there is no objection.
Mr. Lloyd, apart from the accused and the boy and the girl, there are no witnesses to what I have said you need to establish, context and intent. It will not help your case for us to hear still more about the fact that trans-secure guards do carry truncheons.
No, my lord, but it cannot be denied that much wider issues have been raised
But those issues do not concern us, Mr. Lloyd. We are concerned here with only one issue, the incident which has given rise to this trial. It will not help you towards a jury's sympathy, nor to this court's, if you insist on our hearing a mass of evidence and testimony irrelevant to that.
I see.
Mr. Lloyd, do you still wish to press for an adjournment?
No, my lord, I do not. I have no further questions of this witness.
Very well. Mr. Lotterby?
Mr. Cook, did you see the dog attack Miss Nelson?
No, sir.
Yes, she must have seen you. Yet she must have seen you even lying on the ground. She testified. Then the guard came, first one, then another.
Well, it was all over by the time I got there, sir.
Did you see the blow which felled Mr. Latimer then?
No, sir.
Even though you were running towards the scene of the action, you must have been very near by that time.
I never saw it. The light was a bit patchy anyway.
The light of your memory, Mr. Cook.
I never saw it.
Mr. Page, a friend of yours?
I know him.
A friend and colleague whom you wouldn't like to see in trouble?
Nope.
No, he's not a friend, or no, you wouldn't like to see him in trouble.
I don't want to see anybody in trouble.
Mr. Cook, what's your truncheon for?
Self-defense.
Have you ever needed to defend yourself?
Once in the army...
With Transecure, against whom would you need to defend yourself?
Villains, thieves, would-be robbers, people like that.
Yes. Was Mr. Latimer a villain?
No.
Yet he had his skull fractured by a truncheon, didn't he?
Not mine.
Exactly like yours, Mr. Cook. Surely most convincing proof that your truncheon is a deadly weapon. That's all, Mr. Cook.
Mr. Cook, in all your time with Transecure, have you ever known a truncheon be used as a deadly weapon?
No, sir, never.
Thank you, Mr. Cook.
Thank you, Mr. Cook. You may step down.
My lord, I had said that it was not the defence's intention to call Transecure's managing director, Mr. Somerville, since he took no part in the events leading to this case. However, at his own request, I should now like to put him in the box on this question of truncheons.
Very well, Mr. Lloyd.
Yes, well, he's mistaken there. We employ a full-time physical training instructor who makes sure that no one goes on duty before he's been trained in the use of a truncheon.
Then all your employees are trained in the use of their truncheons?
Yes, sir.
Now, how did it arise that security firm guards carry truncheons?
Well, generally, I'm not sure. I suppose one security firm started it and the rest followed suit. But as far as my own firm is concerned, I take full responsibility for their issue. It is in no way the fault of Page or Cook or any other individual.
That sounds conscientious and moral of you, sir.
Yes, well, I think it's quite wrong that anyone should be blamed for this, if blame there is at all, simply for following orders. My orders.
Thank you, Mr. Somerville.
Thank you.
Oh, Mr. Somerville, one moment, please. By giving evidence under oath, you are liable to cross-examination.
Ah, I'm sorry.
Now, at the time of the incident, had Cook been trained in the use of his truncheon?
He had 2 years' training with the military police, I believe.
Oh, yes, of course. Well, at the time of the incident, had Page been trained in the use of his truncheon?
As a long-term employee, it's possible that he hadn't.
Now, in fact, this training scheme of yours was only started when you realized you were going to be prosecuted, wasn't it?
Oh, no, sometime before that.
How long before?
I'm not sure, a good while.
But after you realized charges were being brought?
I can't be absolutely certain of the date. A good many months.
It wouldn't take me long to find out the exact date, Mr. Somerville. Now, answer the question. Did you only see fit to start this training scheme after the events which led to this trial?
Well, if it wasn't before, it was a very short time afterwards.
Yes. And neither Page nor Cook have had any such training with your firm?
No.
In fact, most firms still don't have any training at all with truncheons, do they?
I can't answer for other firms.
Mr. Somerville, have you heard of the Nuremberg trials of Nazi war criminals?
What are you suggesting?
Well, have you?
Of course.
And you know that they were held to establish that following orders is no defence, that every man is personally responsible for his own actions.
Mr. Lotterby, you are not proposing that international law is applicable here, are you?
I know, my lord. I'm making only a general point of principle to the accused.
I see.
You wouldn't claim, then, Mr. Somerville, that because you ordered it, none of your employees should be held accountable for their offences?
What offences? You haven't proved...
Oh, the
that any
jury
offe-
will decide what is proved, Mr. Somerville, but you wouldn't claim that, would you?
No.
Thank you.
So, Mr. Page, this was your first indication that there were trespassers?
Yes, sir. When Fury barked and strained at the leash.
Fury being your dog?
Yes, sir.
Whom we shall meet in a moment.
Yes, sir.
What did you do when he barked?
I blew my whistle and told him to find and hold. He ran, and then I saw what I thought then was a couple of boys running.
And what is Fury trained to do in these circumstances?
To stop and hold the suspect, sir.
Without hurting them?
Well, I mean, he'll hurt you if you hurt him, sir. But if you stand still and behave yourself, he'll just hold you. I mean, anybody knows that.
Now, as they ran towards the fence, did you shout, "Get them, boy"?
Yes, sir.
You did?
Yes, well, that's a command to stop and hold. But I never shouted it when they was going through the fence, sir, nor when they got to the other side.
You didn't encourage your dog to follow them through the fence?
Well, you see, sir, what happened, it's not quite like what they said.
Well, what did happen?
Well, you see, Fury got to them before they got to the fence. One of them was sort of pushing through, like, and the other was sort of standing guard. Well, Fury got to them, and the one who was standing guard, well, I still thought was a boy, he kicked out at Fury, and it really hurt him.
He, now you mean she, Miss Nelson kicked at the dog standing inside the fence?
Yeah, well, I couldn't see which one it was. I mean, one of them kicked him, was the one standing guard. He kicked him and he knocked him down. Well, I was running too, you see, and I shouted, "Get up, boy," because he was really hurt, you see.
Get up, boy, and not get them, boy.
That's right, sir. And then only the once. You don't have a lot of breath when you've been running and you're worried for your dog. And anyway, it was dark. I could hardly see Fury. So if he did go through the fence, I couldn't see him.
If he did, surely.
Well, I suppose so. Anyway, I'm running too, and I'll get to the fence by now, and I can see Fury, the other side, going for the one in the light coat, the one that kicked him. He's a smart dog, that, sir. He was hurt, limping, but he still knew what he was at. He went round the boy with a stick and going for the person that kicked him. Well, she turned, and she kicked him again, under the chin this time, but he still kept going, and he brought her down in the proper way, holding the arm. Now, she never had the sense to keep still, to be quiet, to give in. If she'd had the sense to take the medicine, she'd have been all right. But no, she was fighting and struggling, hitting out at him. She really hurt him, so of course he bit her.
What was the boy doing?
Well, sir, he was creeping up on the dog from behind with a piece of wood in his hand. He was going to clobber him. He was holding it high above his head. He was really going to hit him. So I stepped in and I yelled, "No, don't." Because if he had have hit the dog and missed, the dog would have gone for him. Then that would have been the two of them. So he turns to me and he says, "Keep out of it, you."
He said, "Keep out of it, you," and not as he's claimed, "For God's sake, stop it."
Oh, no, sir, no. I said, "Stop it. Stop still. Don't move," to the girl. He said, "Keep out of it, you." Then when he saw I wouldn't, he came to hit me with a piece of wood.
He actually hit you?
No, sir. I sidestepped, I pulled out my truncheon, and I hit him. I had to hit him, sir, and I knocked him out.
Why?
Why? Well, I mean, apart from anything else, he might have laid me out. Anyway, there was no time for mucking about. The girl was hurting the dog, and the dog was on top of her, and that was the first thing to worry about, not fighting with kids. I had to get him out of the way, sir, in order to get the dog away from her.
How did you get the dog away?
Oh, that was easy, sir. As soon as he felt my hand on him, heard my voice, he came away all right. But, of course, the damage was done by then, sir, and I'm only too sorry it turned out the way it did.
So sorry that you went to see them in hospital.
Yes, sir.
Because you felt guilty for what had happened?
Well, more sorry than guilty, sir. I mean, they brought it on themselves, I reckon, but I was sorry they got hurt, even so.
At what point in all this did your colleague, Mr. Cook, arrive?
Oh, about then, I suppose, sir. He doesn't run so good. Anyway, I had Fury on the leash by then, so Mr. Cook took my coat and his coat and put it over the kids. Then somebody else came along, so we sent them for the police and an ambulance.
So then, would you say that your dog only hurt Miss Nelson insofar as he himself was hurt by her?
Oh, yes, sir. If he hadn't been hurt, he'd have never gone through that hole in that fence.
Very good, Mr. Page. Now, may we meet your dog?
Yes, sir. Fury, come. Now stop, boy. Fury, down. Stay. Fury, heel. Heel. In. Fury. Down, boy.
Very good, Mr. Page. Now, would it be possible to see the dog stop and hold a man?
Certainly, sir.
By your leave, my lord.
Fury, head straight. Go, boy! Stop! Fury, down, boy.
And if the man were running?
Yeah, one moment. Mr. Lloyd, presumably the dog will bring the man down, will he?
Yes, my lord, by catching the arm and pulling him to the ground. It's a harmless manoeuvre, my lord.
Yes, well, even so, I don't really think we can have men falling down in the courtroom. If this demonstration really needs to go any further, we must adjourn to somewhere outside.
My lord, I don't think it's really necessary to hold up the proceedings. Nobody, and certainly not the prosecution, could deny that this is a well-trained dog. Unfortunately, I do not see how the evidence of this demonstration can be admissible.
Oh?
Well, the dog is well-trained, certainly, but how do we know that this dog is Fury? Well, indeed, if it could be shown by kennel registrations or whatever that this dog is Fury, how do we know that it was Fury at Elm Bottom on the night in question? And even if there are worksheets or something with the dog's name on, how do we know that it was this Fury? That one dog has not been mistaken or substituted for another. In short, my lord, how does one identify a dog?
Yes. Comment, Mr. Lloyd?
My learned friend has anticipated most of the proofs, but we do have the dog handler's own evidence of identification. He obviously knows this dog, and the dog knows him.
What do you say to that, Mr. Lotterby?
With the handler's on trial, my lord, his word cannot be corroborated. In my submission, your lordship should instruct the jury to disregard whatever impressions the dog's demonstration may have made on them.
Well, that's damn stupid, sir. Of course it's mine.
Mr. Lotterby, there is some evidence of the dog's identity. May we now dispense with the dog?
Yes, my lord, and thank you. I have no further questions.
Mr. Page, one man's word against two people.
Well, I mean, they're not going to have different stories, are they?
When you were demonstrating the obedience of this dog, why didn't you use the words, "Get them, boy," if that is, as you said, the command to stop and hold?
Well, because you don't always say the same words.
No, not to different dogs.
No,
Fury's a well-trained dog.
Yes, sir.
Trained to stop and hold strong, grown men, or sometimes armed and desperate men.
Yes, sir.
Well, can you tell the jury how it is that a young girl, a little girl, can make not one, but two kicks to this highly trained dog?
Well, she just did.
If a dog was at your throat, biting you, wouldn't you struggle and fight?
No, sir.
Well, I'm sure a great many people would, myself included. So there you were, running towards serious trouble. A girl on the ground being savaged by your dog, boy standing there with a bit of wood, and you hadn't got your truncheon out, had you?
No.
Would you tell the jury how it is that if you struck the boy only after he turned to fight you, as you claim, how it was that the blow landed on the back of his head?
Why, because that's where it landed. I mean, you don't have time to what's name, do you? I mean, sort of sort it all out.
You just hit out, do you?
Yes.
Even at a boy's unprotected head?
I've told you there wasn't time.
Are we to assume, then, that you didn't order this highly trained dog off the girl until after you struck down that boy?
Well, I don't think so. Honestly, I've told you there just wasn't time, sir.
When you visited the boy in hospital, did you offer to shake hands using the words, "We'll let bygones be bygones," then?
Yes, sir.
That's all, Mr. Page. My learned friend called this a test case, and so it is. Certain questions have been raised by this case which must be answered. Just what license are we prepared to allow these private security firms, these paramilitary organizations which take upon themselves the task of defending private property by means of force? I do feel it right that a dog is allowed to savage a child because that child happens to have trespassed inside someone's fence? Do you feel it right that untrained men are allowed to carry and use offensive weapons such as truncheons? Well, it is for you to decide. But I put it to you that a trained dog in the hands of a trained policeman is very different from that same dog in the hands of an untrained transecure guard. And a blow from a truncheon in the hands of a policeman who is trained to deliver such a blow in the safest method possible is far different from an untrained man who just hits out. I put it to you that we cannot allow private individuals to carry these truncheons, and that you find both William Cook and Frank Page guilty of possessing an offensive weapon. Now, it was Frank Page who was responsible for setting the dog onto these two young people and allowing it to bite and savage Miss Nelson. He was also responsible for striking Mr. Latimer on the back of the boy's head, severely fracturing his skull. All this taking place on public land, I must remind you. Though I maintain if it had taken place on private land, it would not have lessened his guilt, and that you find Frank Page guilty on these two counts also. Now, as to the employer of these men, Gerald Somerville, he gave the orders. If you see a trespasser, set the dog on him. And I maintain that this man is as guilty of injuring Miss Nelson as if he set that dog on her himself.
Ladies and gentlemen, it is often said that ours is the best police force in the world, and that may well be true. But it is also true, regrettably, that the police force is undermanned and under strength. And the police themselves will willingly admit they cannot fully cope with all the rising crime of today, nor fully maintain law and order without the considerable help of security firms such as Transecure. Firms who are simply employed to guard the nation's goods and not paramilitary organizations on the verge of running amok and murdering us all in our beds. As to the charges, Frank Page struck the boy, yes. But the boy himself admits to wielding a lump of wood in such a way that Mr. Page, whether or not he was first hit, could well have believed he was going to be hit by it and thus reacted instinctively in self-defense. His dog bit the girl, yes. But no one disputes that that dog was kicked, and even the best trained animal may react to being hurt. William Cook carried a truncheon as part of his everyday equipment for guarding private property at night. He didn't strike anyone with that truncheon. He didn't even take it out of his pocket. But because he went a few yards through a fence to help people in need, he now finds himself in court on the whim of an elderly administrative policeman bringing a test case at the point of his retirement. Against the accused, you have only the word of a less than truthful girl who admits lying on oath, and a frankly uncertain boy who admits provocation, and who both admit they were trespassing, intending mischief on private land, plainly marked, warning, guard dogs. Now, on their thin, inconclusive evidence, and when it is your duty not to convict unless you're absolutely certain of the facts, there is only one course open to you. That's to find all the accused not guilty as charged.
Members of the jury, in this trial it is my function to tell you what the law is, but it is your function to decide on the facts. Now, the two defendants, Page and Cook, are charged with possession of offensive weapons contrary to Section 1 of the Crimes Prevention Act of 1958. Now, an offensive weapon means Any article made or adapted for use for causing injury to the person, or intended by the person having it with him for such use by him. Now, by that definition, you might think that a truncheon is an offensive weapon. That is a matter for you. But even if a man carries an offensive weapon, he is not guilty of any crime if he has a lawful authority or a reasonable excuse. So it is for you to decide whether Page and Cook, as security guards, had a reasonable excuse for carrying their truncheons. Now, Page is also charged with assaulting Latimer with intent to cause him grievous bodily harm by striking him on the head with his truncheon. There is no doubt that Page did strike Latimer, and by so doing fractured Latimer's skull. But Page could plead justification if he acted in self-defense, because Latimer was attacking him or because he believed he was going to attack him. And that is a matter for you. Lastly, there is the question of the dog. If a man sets a vicious dog on a person, knowing it will savage that person, he is guilty of an assault. Now, you may think that if a man sets a dog on someone, knowing that if that person struggles, the dog will bite, then it is difficult for him to say afterwards that he had no reason to suppose that the dog would bite. That is for you to decide. The third defendant, Somerville, was not present at the time of the attack. There is no evidence that he exhorted or encouraged any person to set the dog on the young people, and therefore there is no evidence to support the charge that Somerville caused the young people to be assaulted. I therefore direct you that you must return a verdict of not guilty in relation to him. You will now retire to consider your verdict.
All stand. Members of the jury, will your foreman please stand? Have you reached a verdict upon which you are all agreed? Just to answer yes or no.
Yes.
On the charge of possession of an offensive weapon, do you find the accused William Arthur Cook guilty or not guilty?
Not guilty.
And on the charges of assault with intent to cause grievous bodily harm by the agency of a dog, do you find the accused George Gerald Debney Somerville guilty or not guilty?
Not guilty.
On the charge of possessing an offensive weapon, do you find the accused Frank Gordon Page guilty or not guilty?
Not guilty.
On the charge of assault upon Derek Latimer with intent to cause grievous bodily harm, do you find the accused Frank Gordon Page guilty or not guilty?
Guilty.
Is that the verdict of you all?
It is.
Frank Page was fined £100 for assault with intent to cause grievous bodily harm and ordered to pay £75 in costs. Next week, a chance for you to join another jury in assessing the facts when our cameras return to watch another leading case in the Crown Court.